I'm attorney Chris Benson. A common question we get is, what is a will? Simply put, a will is a legal document where you appoint someone to handle your affairs after you die and designate who should receive your assets after all of your creditors are paid. Wills are pretty simple to create as long as the person is competent, has the required vesting language, and signed by at least 2 witnesses and a notary public. However, all of this doesn't happen automatically. A will only speaks at the time of death. The will must be filed with the court, and the court must accept the will as valid. The court must appoint the personal representative for the estate as well. The personal representative must prepare an inventory of all of your assets and debts and file it with the court for the whole world to see. Until all of that happens, your personal representative has no authority to take any action concerning your creditor claims or your estate assets. So let's look at the advantages and disadvantages to a will. Setting up a will is simpler and a little less expensive than creating a trust. Creditors have a cutoff date to bring claims against your estate. You can appoint a guardian for minors as well. You do not need to transfer any property in order to make a will valid. You simply have to follow the legal requirements for your estate. Well, what are the disadvantages? Obviously, the biggest disadvantage is the expense and delay of going through the formal probate process. There is also a loss of privacy. Through probate, a will becomes a matter of public record, as well as disclosure of all your assets. The probate process can be expensive and time-consuming. Also, a will means nothing until you die. Therefore, a will does not handle the situation where you're alive but medically unable to manage your assets and finances. Anyone who tells you that all you need is a simple will is simply not telling you the full story. There's an old saying, if your only tool is a hammer, you better hope all of your jobs require only nails. Well, what does that mean? It means that one tool can't do every job. Hammers are for nails, screwdrivers are for screws, saws are used for cutting, and so on. In fact, there are even many different types of hammers, screwdrivers, and saws. The same is true for estate planning. One document can't take care of everything you're going to need. However, it's pretty simple to get the tools that you need to take care of everything that's going to occur during your lifetime. A revocable living trust is great to avoid probate and provide assistance even if you're alive but become medically unable to manage your assets. However, a revocable living trust by itself isn't good enough either. You need a will there as a safety net in case you forget to transfer an asset into your trust. You also need a financial power of attorney for financial issues, a medical power of attorney for healthcare treatment issues, a HIPAA healthcare information release so that whomever is going to be making your medical decisions for you have access to your medical records. You also need a directed to physicians, also known as a living will, to make sure your family knows how to handle severe medical issues, a designation of guardian to make sure you have in place a plan to make sure that you have a place to live and food to eat and clothes to wear. You also need to transfer your assets into the trust. While it's true a will is a declaration of intent when you die, who should receive your assets, for most people with children and most people with real estate, a trust is a better approach. If you have any questions, please send me an email. Thank you for your time.